In 2022, the music world was shaken when Jeffrey Williams, better known as Young Thug, faced one of the most controversial trials in modern hip-hop history. What began as a federal racketeering investigation quickly evolved into a story of power, loyalty, and blurred lines between art and crime. Prosecutors accused Williams of leading a street organization called YSL, Young Slime Life, claiming it wasn't just a record label, but a criminal enterprise. The charges? Conspiracy, gang activity, drug trafficking, and weapons possession. On June 7, 2024, during what was expected to be another ordinary day of testimony, something happened that would change the course of the entire trial. A witness, one who had been granted immunity, refused to testify, invoking the Fifth Amendment. Judge Ural Glanville, presiding over the case, ordered that the witness be jailed until he was ready to cooperate. Then, 3 days later, a meeting took place, quietly, behind closed doors in the judge's chambers. Only the prosecution, the witness, and his lawyer were present. The defense knew nothing. That secret meeting would become the epicenter of a legal earthquake, one that raised serious questions about judicial conduct, attorney ethics, and the limits of power inside an American courtroom.
The issue is, how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. And 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you some in substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not sure.
I don't want to hold you in contempt, but this is that serious, Judge. You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you 2 things. One, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have a...
When I got this information...
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele, that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
When defense attorney Brian Steele learned about that private meeting, he brought it to the court's attention, and instantly, the atmosphere in the courtroom shifted. Judge Glanville demanded to know how Steele had discovered the ex parte communication. Steele refused. Citing attorney-client privilege, he made it clear that revealing his source would violate the core of his professional ethics. But Glanville wasn't satisfied. He called for a brief recess and warned Steele that if he didn't name his source when court resumed, he would be held in contempt. In the legal world, this is a dangerous standoff. One man defending his ethical oath, another defending the authority of the bench. When court reconvened, all eyes turned to the defense table and to the man who refused to bow.
That leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right under the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you've already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, ma'am. Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Steele stood firm. he refused again to reveal how he learned about the judge's secret meeting. Moments later, Judge Glanville declared him in contempt of court. The judge argued that he wasn't asking for confidential information, only for the method by which Steele obtained it. But Steele disagreed, insisting that even revealing that would breach his duty to protect anything learned in the course of his representation. It was a philosophical clash, the law versus its own conscience. On one side, the authority of the court. On the other, the sacred duty of an attorney to his client, and the principle that trust cannot be compromised even under threat of jail.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court, now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well, I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor,
Realizing the gravity of the situation, Brian Steele moved for a mistrial, arguing that the secret meeting had violated his client's constitutional rights. By law, defendants are entitled to be present at all critical stages of their trial. That right can only be waived, not silently taken away. In previous Georgia cases, like Scudder v. Georgia, 2016, the court had ruled that such private communications could be excused only if the defense knew and failed to object. But here, no one from the defense had been informed. The meeting had been conducted in secret, without notice, without consent, and without record of approval. Steele's argument was clear. The judge's actions had undermined the integrity of the trial itself. For a moment, the courtroom wasn't just a place of law. It became a battleground of principles, where transparency and authority collided head-on.
none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Mark Huey.
Okay.
We are also adopting all the arguments that have been made by
All right, sir.
Brian Steele, by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an explanation that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got we believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams?
Those were nice, right? And we're doing it on adopting all the motions.
All right, thank you, madam. Motion's denied. Mr. Garner?
To adopt all arguments by the defense attorneys and motion.
Okay, so noted. All right. Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that the court means we'll get started and resume the trial, Your Honor.
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele and without
You don't have that luxury at this point in time, sir. You don't.
the court addressing.
You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue, we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time.
I don't believe so.
Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning
If there is any accuracy to some of the information that we are.
But sir, I don't even know.
Prosecutor Adrienne Love countered. She argued that the defense had no right to be present at that meeting, since it dealt with a civil contempt order, not the criminal case itself. Technically, she was correct. Civil contempt is a separate matter, a procedural issue between a witness and the court. But Steele saw through it. Because that civil meeting led to one crucial outcome, the witness changed his mind and agreed to testify for the state. The line between civil and criminal had been crossed, and now it was impossible to untangle. Even if no wrongdoing occurred, the appearance of bias had already poisoned the well. Judges are expected to avoid even the appearance of impropriety, and this, Steele argued, was precisely that. Still, one by one, the motions for mistrial were denied. The courtroom fell silent, and Judge Glanville turned his focus back to the man who had dared to challenge him.
Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of...
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. and you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
When Steele refused once more to reveal his source, Judge Glanville made good on his warning. He found him in criminal contempt and ordered deputies to take him into custody right there, in open court. The image of a defense attorney being escorted out of the courtroom while representing one of America's most famous rappers was shocking, almost surreal. But later that day, in a surprising act of restraint, Judge Glanville allowed Steele to return, stating that he didn't want to deprive the defendant of his chosen counsel. Instead, he sentenced Steele to 20 days in jail, to be served only on weekends. Steele made an unusual request, to serve that time in the same facility as his client, Young Thug, so they could continue working on the case together. But justice, as always, had one more twist. The Georgia Supreme Court intervened, halting the sentence and eventually reversing the contempt order entirely. The court ruled that Judge Glanville had been personally involved in the dispute and should have recused himself from ruling on it. He was removed from the case. Young Thug later pleaded guilty to several charges, his 40-year sentence reduced to probation and time served. But beyond the verdict, beyond the fame, this case revealed something deeper, a system constantly balancing between authority and ethics.